Is it possible for a squatter to adversely possess a piece of registered land? What is the process and how long does it take? These are the questions I'm addressing today. But first of all, if you're new to my channel, make sure you subscribe so that if you've got questions of your own, you don't miss out on my new videos. If you've watched my first video on adverse possession, you'll know that the Land Registration Act 2002, which came into force in 2003, introduced a scheme for the acquisition of registered land by adverse possession. It was intended to balance the system between the landowner and the squatter in favour of the landowner. However, it is still the case that a squatter can acquire land by adverse possession if he meets the relevant criteria, which includes factual possession for the period of 10 years. You can watch my first video linked below for a more detailed explanation on this, but in short, there needs to be factual possession with the intent to dispossess the paper owner of the estate. So let's take a scenario down on the west side of Dorchester. Mr. Squat has found himself a piece of land and he's been there for just over 10 years now. The original owner cannot be traced. Maybe he's gone to prison, maybe he's just left the country, or maybe he's just forgotten about the piece of land and hasn't tended to it. Either way, Mr. Squat has had factual and intentional possession of this piece of land for more than 10 years. In this scenario, provided that Mr. Squat makes a valid application for registration, paragraph 2 of Schedule 6 of the Land Registration Act 2002 requires the registrar to give notice of the application to all those that might be prejudiced if Mr. Squat's application is successful. And such people or entities that might be prejudiced are as follows. It could be the registered proprietor, the proprietor of any registered charge, such as a mortgage, the proprietor of any superior registered estate, for example, if this piece of land is a leasehold, or any other person that is registered in accordance with the rules to be notified of such an application. So a very important lesson here for any registered proprietor or chargee is to ensure that names and addresses and relevant details are correct and up to date on the register. So many people in the course of busy lives simply forget to change or update their name and registered details on various different registers, and as a consequence will not receive notices and post that could be of a significant consequence if they fail to receive and act upon them, such as in this case with Mr. Squat. If the actual registered proprietor has simply moved and not updated his name and address on the register in respect of this piece of land, he's not going to receive notice of Mr. Squat's application. Because remember, it is not for Mr. Squat to show that he's made relevant inquiries as to where the registered proprietor now lives, and it is down to the registrar to give notice of his application. But let's say by a quirk of fate that the actual registered proprietor gets a copy of the notice of the application sent to him and files an objection. In this case, Mr. Squat's application is going to be rejected unless he can show one of the following three things. The first of those is found under paragraph 5.2. This is where, very simply speaking, it would be so unfair for the registered proprietor to dispossess the applicant of the land, and in the circumstances it is the applicant that should be registered as the proprietor. The second is found under paragraph 5.3, and that is where the applicant has some other reason to be entitled to be registered as the proprietor of the land. And finally, under paragraph 5.4 is where there's been a reasonable mistake as to the boundary lines. But failing all of that, if Mr. Squat's application is refused, but he remains in adverse possession of the land for a further 2 years, he can then make a subsequent application. And in this case, provided that Mr. Squat has been in adverse possession of the land for a further 2 years, he will be registered as the proprietor whether or not there are any objections received. There are, as always, lots of other rules and exemptions. I will cover one or two of them here, but it's by no means exhaustive. For example, if a squatter has been in adverse possession of the estate for 10 years or more, but is then evicted by the registered proprietor, he may still make an application for registration as the new proprietor, as long as the following things are satisfied. Firstly, that the application must be within 6 months of the eviction. Secondly, he must be entitled to apply to be registered on the day before the eviction. And finally, he must not have been evicted pursuant to a court order for possession. As to entitlement, there are at least 4 scenarios where a squatter is not entitled to make an application for registration. Firstly, which might sound quite obvious, is where the squatter is a defendant in proceedings for possession of the land. Secondly, and similarly, where judgment for possession has been given in the preceding 2 years against the squatter. Thirdly, where the registered proprietor is in or detained in enemy territory. This is to do with limitation. Finally, is where the registered proprietor cannot make or communicate decisions by reason of mental disability or some other physical impairment. If you want to learn more about making the application itself or opposing one, or you want to learn more about possession proceedings, make sure you subscribe, drop your questions down below, and check out my channel memberships and look out for live stream chats where I'll be answering questions from super chats. In the meantime, thanks for watching and I'll see you next time.